position probably over a period of 3 years, I think that's what the DSE have said. And it would be certain cohorts of children who come to the end of their phase of education, so moving from primary to secondary, secondary to post 16, or nursery to primary, probably. And it's most likely that the first cohort would be the ones currently in year 5, year 10, because they're going to be transitioning next year, not this year.
Right.
For those who have a school transition this year, it would be too late really, because they will already have had their transition review.
So either the plan is for all statements to be transferred over by 2015, is it?
17.
17, right. So it sounds to me then that it's going to be done in phases and matched up with key stages. So when your child gets to end as a particular key stage, maybe that's the point that they'll transfer it over. But I'd be very concerned, just on that point, if anyone does suddenly find that their statement is brought to an end and they're suddenly not finding that they've been transferred over. I don't think that's the plan at all, but I hope that answers the question.
Sorry, what happens when a child's gone past 18? Do they still have a special needs education plan?
Yeah, I mean, if they would be eligible for a learning difficulty assessment under the current regime, and they've got one at the moment, they should be transitioning over to the EHCP, because this carries on until the age of 25, just like the learning difficulty assessment. But because the learning difficulty assessments are going to be abolished, this is essentially what takes its place. The definition of special educational needs is exactly the same as under the Education Act. This goes to my point that I mentioned earlier, that the criteria is exactly the same. It's a child who has a greater difficulty in learning than the majority of other children and has a disability which prevents or hinders them from making use of educational facilities generally provided in the area. The only thing that I will say, which I think might be worth mentioning, is that the way in which local authorities, and I've seen also tribunals, tend to look at this, is can a mainstream school meet the needs of a child from out of its own resources? And we're seeing in the light of the new school funding regulations, with schools getting money directly from the Department for Education, that schools now have, or are supposed to have, more money than what they had previously. And I'm seeing a shift in decision making, and local authorities are now saying, well, you know, the school's got all the money now from the Department for Education, and so it should be able to meet the needs of your child, and therefore there's no need for them to have a statement or to have an EHCP. I'm slightly concerned about that approach, because I don't think that's really the purpose of a statement, or indeed an EHCP, because actually these are meant to be legally binding contracts between a local authority and a parent to ensure that the child gets what's in there. And if suddenly they are to be done away with because schools are getting more funding, there's potentially a vulnerable class of children who don't have that safeguard, i.e. the statement, where the needs are properly identified and there is an obligation on the local authority to ensure that it's delivered, irrespective of any issue about resources. So that's just something to consider. I think that if you're sort of faced with an issue where local authorities are saying we don't think your child needs a statement or one of these EHCPs because the schools have got all the funding now, I'm not sure that's correct, and so I think that it's worth maybe taking legal advice on that, because if the child hasn't got a statement, then how is the school meant to know what they're supposed to be delivering? The content of EHCP plans, so far as we know it from the existing draft code of practice, it's to contain the views, interests and aspirations of a child and their parents or young person. I think this is quite important because I see lots of statements at the moment, and a lot of them seem to be very focused on all the struggles that the child goes through and all the difficulties that they face and all the negative things, but no real emphasis. I'm not saying that this is all the time, but a lot of the time no real emphasis on, well, what's the views of the child, what are they interested in, what do the parents think, because it's really important for anyone picking up a statement, particularly teachers, to know that information so that if a child is struggling to engage or there's behavioural problems or whatever the case may be, they can go to the statement and say, right, this is what the child has expressed as a view at the time that this was last reviewed, these are his or her interests, let's see if we can build a curriculum around these things or some classes around these things to get the child motivated and sort of engaging again. Special educational needs, so this is essentially part 2 of the current statement. It's essentially divided into 4 domains: communication and interaction, cognition and learning, social, mental and emotional health, sensory and or physical needs. So those are essentially the things that will be covered in education. So if your child has got needs in any of these 4 domains, this is what you should be seeing in the EHCP. Also the outcome for the child over the next 12 months and also in adult life as well. It may be too early to know or say what the outcomes could be for a child once they reach adulthood. But some indication is quite useful so that we don't lose track of that as these statements are being reviewed on an annual basis. Of course, the provision that's needed to meet all of these needs and health and social care is going to be included in these plans as well. Is everyone following so far in terms of what we know is going to be included? The other thing to note, and I suppose this is quite similar to the current regime, is that there's no guarantee or expectation that a young learner has to stay in education until the age of 25. It may be that they don't want to, or it may be that they don't need to. So there's no guarantee that if they've got an EHCP that will continue until the age of 25. And I think the overall aim is to prepare children, young learners, for independence and or employment insofar as that's possible.
Does the Act cover employment for things such as learning disabilities and rather than a physical disability? My sister suffers with something it's not been diagnosed, but it's somewhere in the realm of dyspraxia, and she has quite understanding difficulties with communication. But there's nothing out there to support her with that in employment, and she's losing jobs because she's not understanding the instructions given to her, and she's not getting through interviews because she struggles to get a point across and sell herself. And she's really struggling to get into employment with that, and we can't seem to find anything to support her into that employment. And she's younger than 25, but there doesn't seem to be anything there.
I know that the Act covers things like training and apprenticeships, but in terms of actually going forward with employment, I would have thought that because EHCPs continue until the age of 25, that support would be available until the young person has made that transition to employment, because that's the overall objective. Now it sounds, so hopefully with this new system, the situation that you've just described with your sister would be avoided, because if the aim is to get the young person into employment, that's, the plan would continue until that goal has been achieved, providing that young person with all of the support that they need. I think where your sister is concerned, it may be worth just checking whether she has a learning difficulty assessment, because that, under the current regime, that's available until the age of 25. And so it may be that your sister might benefit from some sort of apprenticeship or college course with a view to moving on to employment. And that will be available until the age of 25 for so long as she needs it. And then you just need to contact the local authority about that and just say, we'd like to be considered for one. Right, the new timeline. The current timescales to get a statement is 24 weeks. So it's a long time. It's 6 months really. It's been reduced by 4 weeks under the new timescales. I won't go into great detail because the information's there for you on your slides. But if you are wanting to request a plan, you make a request. They've got 6 weeks to make a decision. They've then got a further 10 weeks to make a decision about whether to make a plan. Now that's been extended quite considerably from the normal 4 weeks, but I expect that that's because a lot of appeals that I see are because the local authority just hasn't consulted properly with all the multitude of professionals that are involved with a child. And local authorities will say, oh, we didn't have time within that 4 weeks to get it, given how busy doctors are and professionals. So this 10 weeks should hopefully resolve that. So local authorities can't say, oh, we didn't have the time to engage in all of this consultation. And in fact, we know that under this new legislation, they've actually got an obligation to be more proactive in engaging all the relevant services, consulting with parents and young people. So 10 weeks should be absolutely fine amount of time. Then they've got a further 6 weeks to issue the draft statement, and a further 4 weeks to issue the final statement, taking you to a total of 20 weeks for this process to be completed. And of course you know that if there is any element of the plan that you disagree with, you can go off and appeal to the tribunal. One thing that seems to me to be remaining the same is that the appeal to the tribunal, although it isn't expressly said in the Code of Practice, as far as I could see it, although we know it's being rewritten at the moment, is that non-education related health and social care is not a matter for the tribunal. So unfortunately, if there's a dispute about the level of needs and provision in relation to that, you can't appeal to the tribunal, which is a shame. But I'll come on to that later. Right, one of the big things, I think, for parents, is probably one of the biggest things, actually, arising from these new reforms, is the local offer. I think you heard a bit about it earlier in the sessions, but there are 2 key purposes to the local offer. It's to provide clear, comprehensive and accessible information about the provision that's available out there. And as a solicitor, I often get parents coming to me saying, my child's education is completely broken down, I'm at my wit's end, I don't know what's available. And as a lawyer, I have the same difficulty with what's actually out there, Well, the local offer is meant to remedy that situation. It'll essentially be a list of all of the services. It'll be comprehensive and it'll be transparent, and the purpose is to enable parents to log on, go onto the website or however they access information and see what's out there, what's suitable, so that they can go off and start looking at all of these things.
Sorry, just a quick question, because I wanted to ask a question in the main hall about the local offer, and because there were several people who seem to have difficulty accessing certain services because things like the autism team was poorly funded. I know as a teaching assistant and a parent that speech and language therapy services are an absolute crisis, and it's almost impossible to get access to those. Would the local offer be legally binding? Would the local authority be legally obliged to fund certain services effectively and fully in order that children can access those services to meet their needs?
Well, that's a tough question.
Because it's no good having these things listed on a piece of paper unless the service is there.
Well, I would say that they have got a duty to fulfil their obligation to make these services available. Otherwise, why would they include it in a local offer saying that this is what's available when in fact it's not available? It would just be dishonest of local authorities to go around publishing that information. And so my view is that yes, they have got a duty to provide it for so long as it's available and on their local offer.
I think, I think the local offer is not going to be legally enforceable because it will include all sorts of services, including, parent support groups and charity services that are actually not funded by the local authorities. The local authority can't be taken to court for not providing those. And we asked the Department of Education, and they said the reason why they're not actually making the local offer enforceable is because they thought it would become a race to the bottom with local authorities in that case would only put the absolute minimum that they're absolutely certain they can provide. And that's why they haven't made it enforceable.
Yeah, I mean, I think in terms of enforceability, just looking at it from a practical level, if the local authorities are saying, this is our local offer, this is what's available in my local authority area, then to a degree you've got an expectation that that's what's available in the local area. And if the local authority comes back and says, well, or if the individual providers say we're at capacity, we can't admit any further pupils, then that's a different matter. But I'd be very concerned if local authorities didn't act in good faith in implementing their local offers, because actually we know they've got a duty to ensure that the local offer is designed on the basis of what's needed in the area through parent consultation. So if there are gaps in services in the local offer, and parents have voiced concerns about that and no steps have been taken to ensure that that gap is filled, I think that there may be areas in which that could be challenged, and I think that if offers are simply not available, irrespective of them being in the local offer, I think there is a good argument to sort of put the local authority to proof on why it's in the local offer in the first place. So I think that to answer your question, it may not be legally enforceable in the sense that they've got a binding duty to provide all of this. As a public body, they have got a duty to act reasonably and fairly. And so if they're not doing this in the way in which they're creating the local offer, then that gives you a right to take legal action. The second purpose is, well, I suppose I've touched on this, is that the local offer, the local services, are supposed to be responsive to local needs and aspiration through direct involvement from children, young people, parents, carers and service providers. So quite often I get parents saying, well, my child needs this, but there is nothing in the local area. I can't find anything that would be suitable. And so what the purpose of this local offer is designed to try to cure this problem. So it's no good providing me with a list of all these services if actually my child isn't going to be suitable for any of them. The purpose of this is to plug all of those gaps and ensure that every child's needs are met through what's in that local offer. The key requirements of the local offer is that it's meant to be collaborative, so joint working with everyone, accessible to everyone. It's no good it only being accessible to some groups of people. It should be comprehensive. So what the Code of Practice says about it at the moment is that it shouldn't just be a directory. Here's a list of all the service providers in the area, because you could probably go to the Yellow Pages and find that, or wherever, perhaps not the Yellow Pages, but it's actually meant to provide details of what actually the service can provide, what's actually available, so that you can forge an opinion about whether you think it would be suitable for your child's needs. And it's meant to be transparent, so you've got a very good idea from the very beginning but this is what's available in the area. What will the local offer include? Well, in the draft SEN code at the moment, what it actually includes is set out at pages 45 to 57. I don't know if anybody here has had a look at the draft code of practice, but if anybody does want to, you can find the details at those pages. It's to cover a whole manner of things across education, health and social care. So you'll have everything there in one place. It's going to include things like school curriculums, also things about auxiliary aids and assistive technology that's available in particular schools that your child might need. Other provisions such as sports and arts, which might be suitable for some children who can't cope with a full-time timetable at school, might need something a bit more creative. Post-16 provision, including apprenticeships and training, what's actually out there and available, transport, childcare, leisure, activities, and all the information about how the EHCP works and the mechanics of it. That's just a bit of what's included, but I thought those were probably the most important things, but actually there's a whole list of things about what it actually covers. So you can see that it's quite extensive. Just moving on to health and social care, this is a question that gets raised quite a lot. Well, what's this issue about health and social care? What is it going to bring to the table that isn't already available to children with statements? The quick answer is that I don't actually know, because it's not clear in the draft code of practice as it's being prepared at the moment. I've just lifted there what the draft SEN code actually says about health and social care. It says that what will go in the plan is any health or social care provision reasonably required by the learning difficulties and disabilities which result in the child or young person having SEN. Now, I don't really know what that means, to be honest, but I would assume that it means pretty much what happens at the moment, that if your child needs health or social care provision to be able to access the educational curriculum, then that's what health and social care is. Because at the moment, under the current regime, if you've got a child with very significant communication needs, who needs regular speech and language therapy, that's a health need, but it's needed to enable the child to make progress with education. Some children with very significant physical disabilities may need their care needs being met in school with feeding, changing, that sort of thing. Perhaps one-to-one help all the time in some cases. So I think that's what it means, and so in that respect it doesn't seem to be very different to what the system is already. It's required to meet the outcomes that we talked about earlier, that will be in the statement about what do we want to achieve for this child now and in the future. So the health and social care should be included to ensure those outcomes are met. Health is simply defined as anything that's reasonably required, and social care, again, anything that's reasonably required. In addition to that, you've got anything that's not SEN related. So I'm just trying to think, anything that's not SEN related may be things like physiotherapy, which is not a part of the educational curriculum. In fact, in a lot of cases, physio may be part of the education curriculum. So that's all we know about health and social care at the moment. I expect that it will be refined more when the new code of practice has been rewritten and issued. But at the moment, I'm afraid we don't know a great deal about how health and social care is going to operate within the EHCPs, other than what I've been able to lift out of the current code. There's going to be a duty on local authorities and NHS bodies to establish joint commissioning arrangements. So I don't know if a lot of you come across a difficulty at the moment where local authorities and NHS bodies are sort of in disputes with each other about who's going to pick up the tab for this speech and language therapy or whatever the case may be, and you know the child gets caught in the middle and there's usually a delay and so on and so forth. Well, what this new legislation seeks to do is put a duty on those bodies to come up with a plan of action. This is what's needed in our area, and this is how the commissioning of that is going to work, so that the commissioning of it for an individual child can be done quickly. There's no messing around, oh, who's going to pick up the tab and a year or two goes by and it still hasn't got resolved. That there should be a very clear arrangements in place so local authorities can get on and do what they need to do to meet the needs of the child. The commissioning arrangements will include education, health and social care. So again, it's just going to be one arrangement, and there shouldn't be any disputes about funding, or I certainly hope not. I did hear actually that it was said, I think at one of the sessions this morning, that the local authority has only just started talks with other bodies. So at least we're on the right track in relation to that. There's a duty of cooperation between bodies as well. So the NHS can't simply say, oh, well, we don't want to get involved in this, or making life difficult. They've got a duty to cooperate. There's going to be a designated health officer appointed under this new regime to coordinate services between health and education. Hopefully that might make things easier too. And I think the important thing to come out of this, which I mentioned earlier, is that the services need to be based on evidence about what services are needed. So this just goes back to the point about you've got to have consultation, parent and child engagement, where are the gaps in services, what's needed, these services have got to meet it. That's essentially what this is meant to be achieving.
Angela,
Yeah.
about 10 minutes.
Yes, I think I'll just go very quickly onto the personal budget. I think I'm almost done actually.
Lunch starts at 12:30, we have plenty of food, so don't worry.
Yeah.
The workshop doesn't start until 1:45, so we should have enough time for lunch.
Personal budget very quickly. A local authority can be asked by a parent to do an assessment about the availability of a personal budget. Local authorities then got a duty to do one. It will cover special educational needs, help and care. Now, at the moment, personal budgets and direct payments are already available for social care. They're not for help and they're not for education, so this is going to be a new thing. Don't actually know how it's going to work in practice because it is still going to be in pilot phase. And it's a budget that's going to come from education, health and social care, so I expect this will be linked in with the joint commissioning arrangements we talked about. So what this does is it gives greater control for parents and young people. If parents want to use personal budgets or direct payments, they might not want to. The delivery of the personal budget, so how are you actually going to get the money? How is it going to be used? Well, what the Code of Practice says at the moment is that you can get it in 4 ways. You can have a direct cash advance, which you manage yourself, so money in the bank, and you use it how you think appropriate to meet what's in the plan. That's an important point actually. You don't just get handed a cheque and told, well, you can spend it on what you want. It's got to meet what's in the plan. The second is an organised arrangement where the local authority keeps hold of the money and commissions the services on behalf of the parents. And then also third-party arrangements, nominees, where local authorities pay a third party to manage the funds. Now, I get mixed responses about personal budgets and direct payments. Some parents think they're great, they've got more control, more choice. Some parents find it too onerous to deal with payments and all the work that goes into accounting and reporting back to the local authority about how the money's being spent, finding the services. That's under the current regime. So I would imagine that the local offer will tally up with the personal budget. So you've got this personal budget, you use it to spend on what's in the local offer. But that should make it easier than what we've got in the current system. Or fourthly, a combination of all of those. I'm just conscious of time, and I wondered if there's likely to be any questions and answers that we might deal with. You've got the slides for the remaining sessions. Is anyone likely to have any questions, or shall I just plough on for the next 5 minutes? Yeah. I'm going to be available as well over lunch and for the rest of the day. And actually, there are some legal workshops that are happening later on today. I think we have any booked now. If you're booked on that, you can have sort of a one-to-one with me, or alternatively, my contact details are on here on the slides. So if you want to contact me after today, email me or telephone me about any matter that you want to discuss in confidence, then please do.
I just mention that we're running the legal advice sessions again with Irwin Mitchell, and there's a flyer on our store, so you can book your 30-minute legal advice slot.
Yes. Right, challenges to the first tier tribunal is pretty much the same as under the current regime. Refusal to make a plan, refusal to prepare one, disputes about what's in it, refusal to reassess needs if the child's needs have changed, refusal to amend after a review, and then bringing it to an end before the age of 25. You can appeal all of those things to the tribunal. Obviously, you have to consider mediation. If there is a dispute about not getting what's in the plan, you can't appeal that to the tribunal. That remains the same as what's under the current regime. You've got to complain to the local authority, and in cases where things still aren't getting done, it's a judicial review, which is the legal challenge that I mentioned earlier. Child's rights of appeal. Actually, sorry, this was actually very important. I'll just run through this very quickly. I don't need to go through good points and not so good points, possibly. But the child's rights of appeal, this is, I think, has been concerning parents, because one of the things to be introduced under this new regime is that children themselves will have a right to appeal from the age of 16 without needing parents to do that for them. So I can see that this might be useful if there's a conflict between the child and the parent, or if the parent is just simply not able to launch an appeal themselves. And this probably won't apply to all of you, but I have seen cases where children are reaching teenagers who have got parents who just have got their own difficulties and just do not have the ability to reach out and engage in these appeal processes, and so it just gets left because it's got to be a parent who appeals to the tribunal under the current regime. It's only the parent who has a right of appeal, nobody else. And so this would be quite helpful in that respect. But then I suppose you're saying, well, what about, I know what's best for my child. I don't really like the idea of my child going off and appealing and me not being able to do anything about it. But, if you disagree with what the child is seeking, for example. Well, the important thing is that the right of appeal runs alongside a parent's right of appeal. So essentially, if a child decides to appeal, and you disagree as a parent, then you can bring your own appeal at the same time, and ultimately the tribunal will decide what's going to happen. If you're thinking about, well, my child just hasn't got the ability to understand how to bring an appeal, or whatever the case may be, there is the option of choosing a case rental system. So this is quite similar to what as lawyers call litigation friends in civil proceedings, where if a child is under the age of 18 or they've got mental capacity impairment, they need an adult who is capable of bringing the proceedings for them, but acting in the best interests of that child. So this is a similar thing really, but it's called a case friend. That case friend has got to be suitable, so there can't be a conflict. And if the tribunal sees that there isn't a case friend from the very beginning, they can actually order that a case friend is appointed for that child. It's only a pilot scheme, so it's not all finalised yet, and it's not yet, I don't think, indicated who the pilot local authorities are going to be. So actually I don't know whether Sheffield will be one of them. So this is a pilot. It may not apply to Sheffield immediately, and the end result is yet to be determined once the results of that pilot scheme are known. So I hope that addresses the concerns that I think a lot of parents have about this particular topic. I don't think it's probably as bad as it seems. Actually, it's supposed to be a good thing.
I think Angela,
yeah, of course. So that's it. And then just a little bit about good points and possibly not so good points, but you can read that on the slide. Thank you. Thank you.